Hey Lou, how you doing?
All right, how are you?
Good.
Good, good.
Don, are we all set?
We don't have Matt yet. Do we have Matt?
Lou, I'm on.
Okay.
Okay, good afternoon, everybody. This is Brian Barr, your host, your MC for this roundtable. Thank you all for attending. I know we have some visitors or some guests. We have Matt Bender, Zach Kozlowski, Matt Moreau, Matt Stahowiak, and was there one more as well? Okay. What we're going to do is we're going to have this be a roundtable to identify issues that we see in the front lines, how best to address them, a lot of the legislative, both national and federal levels, what's being considered, what has a chance of passing, what doesn't have a chance of passing, which is probably most everything else. If there are any questions or comments, feel free to interrupt and ask if you have some pointers or some questions about how to handle this. So what we're going to do is we're going to have Nick Sansoni, who is with our firm, handles the legislative and attends the RIMS meetings for the legislative response, both from the federal and national level. We also have Lou Needleman, who will be speaking as well, and I'll kind of clean up at the end. So as the roundtable format goes, we're going to ask what questions you may have, interactions you have, cases you may have, policy language, and with that, I will leave it to Nick.
Thanks, Brian. Actually, I would ask the participants what issues in particular you have been seeing so that we know how to focus this roundtable. We can focus, for example, on the type of policy issues, including the language in the policies, the terms and conditions, the exclusions, the type of forms that are used. We can focus it on the coverage issues, such as first party, general liability, a little bit of comp, event cancellation. What type of general claims have you been seeing or anticipate seeing as a result of the COVID virus?
We've received some, on the general liability side of this, we've received some claims that are mainly notice claims. Okay. We're being put on notice by the ones I've handled, all the general liability ones, and they are notice claims in the event that there is some type of mandate from the individual state governments to force coverage down onto the GL policy. These are on the CG form where we do have the communicable disease exclusions.
Which ISO form did you use, if you don't mind me asking? For the exclusions.
You know what, you're catching me off guard. I don't have my form in front of me. But bear with me a second and I'll grab it.
And let me tell you, while you're doing that, let me tell you the reason why I'm asking. For those that don't know, ISO is the Insurance Services Offline Inc. We know them as the ISO forms. The most popular one that's being used right now for, quote, business income is CPOO 30-10-12. You then have three forms that are being three ISO forms that are being used for these exclusions. The coverage language that you use is really important. And we'll get into that in a moment. But that's why I'm asking, because if you use the right one, which is used 95% of the time, as it stands right now, your exclusion is a straightforward issue.
Nick, is that a first-party exclusion or a third-party exclusion?
It will apply to both. The ISO should be the same exclusion. It should apply to both, which is why I was asking which one in particular is being used.
Now, Matt, you said that these are GL notices, right? So these are claims that have been made against your insured for these types of damages?
Well, that's just it. They're really not claims. They're putting us on notice because they have people in their habitational risk that we have. They have people in the buildings that have tested positive for COVID. They're not saying they got them in the building. The insured was put on notice by those individuals that they had COVID, And the insured took it upon themselves to then put us on notice saying, we understand there's an exclusion on the policy, but we want to put our stake in the ground here in the event that's that there's some type of mandate from the state insurance commissioners to cover these potential losses.
Is there any other type of claims that anyone on the meeting here has been faced with? Because if not, we could focus specifically on that type of issue for GL, as well as the legislative and the state issues that have come up. But any other type of claims that you're looking at?
We've gotten a lot of, and I work with Matt at Hartford Mutual, we've gotten, I don't know, somewhere between 350 and 400 business income claims on property. Okay. That's my focus mainly, is the property claims. And I would say that pretty much exclusively that has been business interruption. And they're on the form you mentioned, the CP 30 version 1012.
Yeah.
Of course, we've also relied on the special form, coverage form.
Yep.
And also the business owners coverage form as well. I think it's the July 2013 version of the business owners coverage form. And I don't believe that we've had one claim where there's even been a question whether or not it's covered. But there seems to be kind of this debate between some of the policyholders that I'm speaking with and, their agents and or attorneys that they may have spoken with about, does the mere presence of COVID-19 on premises constitute physical damage?
That is the exact
has come up.
Yeah, that's the exact argument that they're going to make, and I was going to get into that.
Yeah.
Perfect segue. So, talking about that, let's start with the policy itself. Your policy, as far as I'm aware, should have, if you have the standard exclusion, there is a specific exclusion for the word viruses. Now, the question comes down to this. How is the term virus defined in your policy? Unless the term virus is defined in the policy, the plaintiff bar is taking a position that virus is a very specific definition as set forth in the medical literature. Depending on which expert you ask, the coronavirus is technically not a virus. The reason it is called COVID-19 is there are 18 prior strains of COVID that have been found. The argument is coronavirus has an innate nature such that when it is not in contact with a host, it is technically not alive. It is literally in a state of dormancy. The minute it comes into contact with the host, which in this case is humans, it bonds with certain of the molecules in our body, and that is when it becomes active, and that is what it feeds off to reproduce. So the first issue is, does your policy define the term virus? That's their first argument. Second argument is, the defense that's given to that is, it's a virus, it's called the COVID virus, end of discussion. Our exclusion specifically says virus. Second argument is, does your policy include the term pandemic? Literally, 90% of the policies that I have reviewed personally do not have the word pandemic in it. The standard exclusion that has been used has not been updated for a while, it has now, but does include the word pandemic. So a lot of the arguments coming in will assert that we as an insurance company, or we as a homeowner, I'm sorry, did not buy insurance coverage that excluded pandemics such as this. So the real key out of this, if you take nothing out of this other than this one piece of advice, the first line of defense is looking at your insurance policy itself to check the language. The second argument is your policy should contain exactly what was just discussed. Property damage is the only thing covered. Does the presence of a harmful substance at or on a property constitute property damage? There's actual case law out there that says when ammonia was spilled accidentally into a facility, even though the property itself isn't damaged, because let's face it, ammonia can be cleaned up. that still constituted property damage, and that's actually a New Jersey case. There are cases throughout the United States that say if you sustain physical damage, it does not mean that there has to be an actual structural alteration or physical harm to a piece of property, whether that's a wall, floor, etc.
Nick?
Yeah, please.
Nick, Lou has met and interviewed an infectious disease doctor, and I wonder how much the medical aspect of this particular disease. I know the virus. There's still a lot of studies going on, but if there's anything Lou can share with his interview and meeting with the infectious disease doctor.
I can. I had a conference with an infectious disease doctor locally, and I received the medical jargon that nowhere appears in any business owners or general liability policy. And I'm just going to give you an idea of what these medical terms are. Pathogen. Microorganism, parasite, infection. That's just an example of words that you won't find in any of the insurance policies. As Nick alluded to, there's also a complete absence of pandemic or epidemic in any of these policies. I have in front of me two policies. One is a BOP, a business owner's policy, and the other one's a GL policy, both issued by Hartford Mutual. And I intend during this hour session to take a look at these policies and give you my take on what should be the policy going forward as opposed to where we are now with past coverages. Okay. So Nick, why don't you carry on?
Okay, so let's get back to property damage. The number one question that the plaintiff bar asks when it comes to the defense argument, is there property damage, is very simple. What is your policy's actual definition of property damage? Does it say that you need physical alteration? If it does not, their position is that you do not have proper language in there. It must be read broadly to provide for coverage. Therefore, you as the carrier who wrote this policy must provide coverage. Now, what's the defense for that? The defense is very simple. There is law out there as well from the positive side for the carriers that says what constitutes physical damage. For example, if someone comes in here and spills a soda on the floor, that technically would be physical damage to the extent that if you have some type of need to clean it up and bring in a cleaning company, theoretically, if you had to close your business, that would actually be covered. However, when you're talking about a pandemic, the pandemic itself is not present the way it is currently formatted. The COVID-19 cannot last on a surface for more than a defined period. So even if you do have an issue with the COVID-19 where someone came into your facility and coughed before everyone put into place the appropriate procedures with the wearing of masks, with the stay home, etc., unless they somehow got it on your property and it's outlived its useful life of 3 days, the business interruption is clearly defined as a set time frame during which it should be cleaned.
So Nick, what Matt Stahowiak talked about, getting notices for buildings with Corona tenants. Now, would that, you think that the notice issue about giving them notice of a claim because of that temporal aspect would have something to do with, say the claim, the suit is filed 6 months from now. Does that temporal aspect, does that have anything to do with for notice purposes only, do you think?
Yeah, right now, the only thing that they've been notified of is we may have a potential claim. Or if they have been given a business interruption loss claim, at this point, the response should be simple. Please take a look at our insurance policy. The policy says that we specifically exclude anything to do with a virus, number one. Number two, you must have an occurrence as defined in the policy. Number three, even if you do have an occurrence, you need to suffer for a business interruption loss. And again, we're going back to the ISO forms, which I'm assuming we're talking about here. You must have physical damage. The fact that someone comes into the building and sneezes on it technically is not physical damage. You can literally wipe it with bleach or with a Clorox wipe or some similar nature and resolve the issue. There's no physical damage to the property. Unless and until the legislature changes that, or until the courts change it, that's the position you stick with.
How about if you hire a cleaning company? Say you've got someone that was, was sick in your office and you have to hire a cleaning company to do the A to Z sterilization. Is something like that going to trigger coverage?
No, because there's still a virus exclusion and there is still no physical property damage. But that also leads to a good point. Thank you, Brian. I'm glad you brought that up. There are other claims that are being made for this. Specifically, and we're still on the property, we haven't gotten to the GL yet, but you have claims being made, for example, for damages to customer supply. And I don't know, Matt, if you've seen any of them, which are called contingent business interruption, which means, for example, my customers can't get here because the streets closed off because there was an issue, or the governor issued an executive order, which is also another argument that the plaintiff bar is making, which is your civil authority exclusion. Or not exclusion, I'm sorry, civil authority coverage. What happens if you work at a mall or you own a property at a mall and the mall closes? That is something that attracts business to you. That's called a leader property. Does your policy contain coverage or an exclusion when there is a leader property that's closed that won't let you bring in customers? My position, at least, it's excluded. Your business can remain open. Just because the mall's closed doesn't mean that you are closed, and you do not have physical property alteration or sufficient property damage to bring this claim. Has anyone seen these type of arguments made against them? Matt?
No, most of what we have seen has been related to the civil authority. We insure a lot of restaurants and so forth. So most of what we've seen is that so far. So I haven't seen anything more complicated like with the contingent business interruption claims or anything like that, but that may be on its way. We're kind of seeing what I would describe almost as like a second wave of claims. Now that people are back in business, they know exactly how long they were down, and a whole new crop of claims that seem to be coming in little by little.
Well, let me give you some examples of what you're going to be facing, because it is coming. Supply chain manufacturer. I do construction work. I'm a restaurant. I can't get beef. There has been a large issue in the United States with beef. I don't understand why. I can't see the cows being affected by Corona. I can't see the farmers being affected by Corona. The problem is when you get to a packing plant or slaughterhouse. So I'm a restaurant. I literally can't get beef. I can't get butter. Those issues are what we're considering in the contingent business interruption claims, which is up the supply chain. What happens if I can't get beef and I'm a restaurant? What happens if I'm the most famous Philadelphia restaurant of Geno's or a steakhouse and I can't get beef? Does that constitute property damage? Or is that a contingent business interruption? I literally can't proceed because of somebody up the line ahead of me. What about if the boat that's transporting beef from overseas can't get there? You can't get your beef. You can't proceed forward. There has been case law out of the Southern District that says a food processor had property damage, believe it or not, because the Army Corps of Engineers flooded the Mississippi River boat channels and farmers lost their crops. And therefore, the food processor at the end of this had a claim for contingent business interruption. Believe it or not. Now, are these rulings few and far between as of today? Oh, absolutely. I mean, it's going to be tough for them. The biggest issues that they are hanging their hat on, just for business interruption, we'll get to GL in a minute, is you didn't define what is property damage. That is on you, carrier, so that's your fault. 2, even if you do define property damage, you do not say that it has to be a structural or physical alteration. So that again is on you. 3, your exclusion does not include those terms that Lou just told you. And that's the biggest thing, and Lou hit it right on the head. If you don't have those terms in there, you've got a problem, because I'm the plaintiff attorney who's going to go out and say, this is a pandemic. This is not a virus. Let's get the doctor to say exactly what it is. But to just touch real quickly on the civil authority, closure of a public place. Do you have any type of limits set on your civil authority? Is there any sublimits?
I don't recall off the top of my head. Usually, as opposed to a sublimit, I feel like it's a time limit. I want to say like it's 4 weeks or something that the civil authority coverage might be limited to, off the top of my head. But I don't remember any sublimits.
All right, take a look, because some of the ISOs for that have sublimits not only on the time that a business can be closed for civil authority, and I thought it was 2 weeks.
Maybe it is too.
But the other issue is the amount of money that can be spent for civil authority losses. I've seen the sublimit 10,000 a lot. Now here's the question: is that every occurrence? Is it every day? That can add up pretty quick. And if you want an example of that, and then we'll move on to the next issue, Acme has filed a lawsuit against its carrier in one of the Midwest states, and I apologize. I know one of my partners had talked about this. They filed suit for $1.1 billion, claiming that every single day, every single store was an occurrence. And the $1.1 billion was for less than a month, and that was just profit. So you have to watch, is that going to be covered under business interruption and specifically under the civil authority? And that's what they're arguing. That's exactly what they're arguing. But Brian, that brings us, what was issue number 2 that we wanted to address? Is that general liability?
Yeah, the GL, you covered the first party issues, and if you could touch on some of the third party issues, and to the extent the exclusions are for both, or for one and not for the other.
Okay,
Hey, Nick,
let's go.
Nick,
I guess it's easier to go right to the general liability issue.
Hey, Nick, can
Yes.
you hear me? Yeah, Joe Deal. I just had a question for you, still staying on the first party, and I may be getting ahead of you, but other than the definition of whether it's a virus or not a virus, any other ambiguities that you see the plaintiffs bar arguing in their favor in terms of the policy language?
100% yes. And Joe, if we had a couple hours to go over this,
Right.
we'd go over it all. But I'm trying to hit just on the main points. The main points have been that your exclusion should not apply because of one part of your policy says we cover specifically business interruption, period. It does not define what the business interruption has to be caused by. You are then going to argue exclusions. The problem is that they are inherently, unless you define what is covered versus what the exclusion is, by definition, everything is covered. And if you have a very limited exclusion, you have a conflict in the language of your policy. The ISOs have inherent conflicts in them. I cannot emphasize this, and this is something that's been discussed in multiple national conversations amongst insurance carriers. What do we do to address this? Because our ISO or our standard GL policy or our standard business interruption policy, almost everybody uses one of the ISO forms.
And I'm going to speak to that, Nick, when I have a few minutes. I'm going to speak to that very issue.
Oh, beautiful, beautiful. Do you want to handle that, Lou?
Should I go?
Yeah, go ahead.
Okay, let's talk about the ISO. There is such a concept as proprietary insurance language. And many insurance companies create their own proprietary language separate and apart from the ISO forms. Our office, in preparation for today, checked with the ISO product development director His name is Mark Kinder. And he told us that insurers may use their discretion to develop their own insurance products. And these would be called proprietary policy forms, endorsements, rules, etc. So there's no prohibition about that, and you don't have to use the ISO forms. The risk of not using the ISO forms is that the ISO forms have a 100-year history of being interpreted by courts. And if you, Hartford Mutual, Allstate, Nationwide, if any of those companies decide to design their own proprietary forms to meet certain risks, then there's not going to be any legislative or judicial history that will interpret those forms, and that would be a novel issue for the legislature and the courts.
Lou, I hate to interrupt you, but I had a coverage case that I was arguing at the appellate division, and it was exactly that. It was a proprietary, or they called it a manuscripted endorsement. And the appellate division asked me, Mr. Barr, can you tell me a New Jersey or other state case that interpreted this provision before? And my answer was no, because there were none. Fortunately, the court sided with my client's exclusion because it was pretty clear, but you're exactly right. When you manuscript your own endorsements, you're going to be faced with, you're not going to have the legislative history or other case law from wherever that's going to support you.
And it is a balance of issues. It's a balance of the risk of excluding claims because of an all-encompassing exclusion clause versus being subject to having a court interpret your proprietary language at risk to you because that may be a form that you have put out to 10,000 insurers. We also checked with the Department of Insurance in New Jersey, and we found this to be common ground among many states. If you prepare a proprietary form, you must at least run it by the State Department of Insurance to make sure you have their written blessing to issue that form for your insurance. So that's my piece on proprietary versus ISO.
Beautiful. Thanks, Lou. All right, so let's go to general liability because I've heard we've got a lot of claims related to that. First thing is you have your restaurant claims. You have your nursing home claims. I can tell you from experience and talking to an adjuster right now, our firm is involved initially in a claim in Louisiana where police are being, or not police, I'm sorry, the Prison Bureau has been put on notice of a potential class action for failure to protect against potential COVID for prisoners. The biggest take out of this for general liability is very simple. How do they, being the plaintiff, prove that it occurred at this location? Especially if you're talking about restaurants. And Brian and I had this discussion yesterday afternoon here in the office where we talked about this. It's similar, and the best way I could explain this is it's similar to food poisoning. Everybody's gone home and been sick after eating or going out to a restaurant and says, wow, I got sick because I ate at that restaurant. And not too many people understand the actual mechanism that is involved when it comes to food poisoning. Unless it is a very, 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 very specific type of bacteria that is involved, food poisoning does not happen immediately. You've got an incubation period. In addition, you need to identify a point source outbreak. The exact same issue applies here. Just because someone went to your restaurant does not mean that they can prove that they became ill from eating at your restaurant. If you have children, which I unfortunately have 3 of them floating around my house now, who are going to school or are going out and doing whatever, playing with their friends on the street, you can tell a kid wear a mask all you want. And as soon as that kid gets outside on his or her bike, or as soon as they get outside with that basketball, football, or whatever destruction they're doing outside, playing a sport or just playing, the odds are so much greater that they caught it from their 5 friends that they're not social distancing than it is that they got sick from your restaurant. On a food poisoning case, for example, which is again virus infected or bacteria infected, unless a plaintiff proves that there is a point source outbreak or has the actual product, it's almost impossible for them to prove that you have a general liability claim. Now, for restaurants, for nursing homes, they still have to prove it, but the problem is when you have 10 people at a nursing home who get sick, who haven't gone out the door, they've got a pretty good argument that they got it from that nursing home. Hospitals, restaurants though are a different category. The medical facilities or the storage facilities where the individuals who get sick are not outside or in contact with others other than in that environment, right now have the strongest cases to make these arguments. The ones where there is open environments such as restaurants, malls, shopping facilities, shopping centers, supermarkets. I can tell you straight up that Wakefern is anticipating a wave of these type of claims. They're just waiting for them to come in because people are going to say, I was in your supermarket and I got sick. We've already got some, but there is no point source outbreak. So,
Nick, in the supermarket, I'm sorry, in the supermarket context, do you think it would be important if you know what the employees of the supermarket, whether there was an outbreak?
Same issue, Brian. You're back to the point source. They got to prove the point source outbreak. So if it's in the supermarket, that does not mean, now we're starting to get into comp a little bit, but that does not mean that it came from the supermarket.
No, what I'm saying is if I'm a customer at a supermarket and I want to blame the supermarket, wouldn't it be important to find out how many of the employees got sick? Because if the employees that are there all the time don't get sick, I think it's much harder to prove your case. Would you agree?
Oh, I agree 100%, but here's the problem. Unless the employee reported it as a workers' compensation claim, how are you going to find out if individuals who work somewhere became ill? You're getting into HIPAA issues. You're getting into medical privacy. So unless they are part of an overall claim, you can ask, for example, any supermarket or any restaurant you want. Were people sick? And the restaurant theoretically is violating HIPAA if they say yes.
Nick, on that same issue, can't you look at a lot of the tracing that they're trying to do or the states are required to do for opening as your proofs of the source?
Yes, I was going to get to that. That was actually my next point. But very good lead in, Tony. If at this point someone becomes ill and they are going back and doing tracing, you can figure out possibly whether or not it came from your restaurant. I am sure, though, that the bigger issue you're going to face is a lot of these claims came in before they actually started doing tracing. If they do the tracing and go back and they go to a facility and find out that it did come from your restaurant, that does not mean you're liable. It just means, did you act reasonably under the circumstances? They still have to prove that you did something wrong. If your restaurant is doing takeout, did they sanitize the areas? Did they request that someone keep 6 foot distance? It's not automatically that you're responsible just because someone went to your restaurant, your supermarket, your prison, and became ill.
Well, we're seeing that in the news today significantly from various bars, various facilities on how they're failing to do social distancing. New Jersey, we've had one in Belmar that becomes an issue. And because of that notoriety, are you actually going to be able to get some sort of coverage once you get that tracing proof, once you get that at least a prima facie case that I can go forward with it to get into that aspect of the GL?
Now, if there's an exclusion for viruses, you've got your exclusions, which we're going to get to in a moment, because there are defenses to both GL and to first-party business and comp, for that matter. So that leads to our defenses. Let's talk about the defenses that we have in general that we can utilize in this type of cases. First one is very simple. You should have an exclusion for viruses or biological agents in there. It could be a standalone exclusion. It could be incorporated into your contamination issues. It could be incorporated into your specific language for the business interruption. Could be incorporated into your GL because there is a list of specific exclusions. And then there is the standalone, which again is an ISO, and there's 3 of them. Second,
ours is the 2132.
2132. Okay. So you know what you've seen that, obviously. There are defenses in there for exclusions. Does it contain the word, if I'm correct, virus? Pretty sure it does.
Yes.
I don't think it doesn't contain the word pandemic.
No.
So that's where you get back to.
Actually, Nick, the title is, I think, Matt, the title is Communicable Disease Exclusion. Am I right?
Correct.
Okay.
So that does not, that's a communicable disease. What's that defined as?
There is no definition.
There you go. There you go. Is this a virus? And it leads us back to that same issue. I mean, we're talking about technically, is this even a virus? Is it a communicable disease if you look at just the definition? And that's the problem you run into. There is arguments made that this does not fit your policy. Whether or not it's an ISO form or not, you put this out there, it's your baby. If it's yours and you don't say, I am excluding X, I am excluding Y, and I'm excluding Z. And just to be clear, COVID is not a living microorganism in its original state. So again, is it a virus if it's not a microorganism that's living, which is the definition of virus? It's a lipid-covered particle composed of spike extensions that once introduced to a host, the outer layer melts and the inner core becomes activated and grows. So the argument is that's not a virus. My position, it's excluded under that policy language because it's communicable. To say that that is not within the definition is ludicrous. You stick with that position, and that's it. Second defense usually comes up is sublimits or waiting periods, which we talked about before. Check the policy language. There should be language in there saying that even if they get over everything else, the only thing that is covered is the time to actually repair, and that is the term that's usually used, actual repair, because it exists for such a short period of time. Now, you want to know the counter argument to that is it closed because of that actual period or to prevent spread? That's your defense as well. If they're saying if the client or your insured is saying, I closed because somebody came in with coronas and sneezed. Corona. Okay. How long does it take to clean up? Tops, 3 days, 72 hours? Tops. Are you now closed the rest of the time to prevent it from spreading? That's not what business interruption insurance was designed to handle. It's not what you wrote. It's not what you intend to cover, and it's excluded. So that usually is a very, very, very specific argument that the plaintiffs make. They don't like that counter argument that you're not closed because of the virus. You're closed to prevent other people from getting it. It's not your job to protect society as a whole. It's your job as an insurance carrier to cover your client for the time where it had business interruption due to what's covered under the policy.
So Nick, I kind of want to move this along a little bit. There may be other exclusions, but in light of if you interpret the policy as it's written, there's probably not coverage for most of these claims. What is the political legislative response to the likely absence of coverage?
Very good question, Brian. Well, let me just touch on three more. I just want to touch on three more exclusions because this is one of the main things that our roundtable really has to cover. But the mere presence of virus, does that cause or constitute property damage? The answer, in our opinion, is no. We've talked about the non-structural alteration. We've talked about the need to repair. And then the last thing I want to touch on is actual loss versus speculation and mitigation of your damages. Please consider that if there is not actual loss to them and they are speculating that on a Friday I should have made X amount of dollars, you do have defenses to that, and it is extremely strong. All right, now let's talk about the legislature. As Brian indicated, we are tied in with RIMS, and in doing so, our department has been involved in the trenches of what's been passed or tried to be passed, not only at the federal level, but also at the state. Our department had the pleasure of actually reviewing the federal legislature before it was introduced. So right now, the legislature that's been passed for the federal level is the PRIA, P-R-I-A, Pandemic Risk Insurance Act, which is HR 7011. HR stands for House Resolution. What does that act mean? Well, if you want a copy of it, I can send it to you because it's about 67 pages long. And if this is passed, it will literally upend and destroy the insurance industry. The PREA Act was designed such that starting hopefully in 2021, but they're trying to retroactive it to 2019. They are saying that every insurance company in the United States has two options. You sign up for PREA or you opt out. If you sign up, you are agreeing that you will pay 5% of every single claim that is submitted for business interruption, despite any exclusions, despite whether or not you even wrote that type of policy, whether or not you have the business interruption language in there is an argument that's still being made. In English, even if you wrote a policy that did not offer business interruption, according to PREA, you did. And according to PREA, they don't care. They are saying that every exclusion you have or had is now null and void. It's automatically covered. Now, the government at a certain point will pay a percentage. When the industry as a whole pays $250 million, PREA kicks in. That's when they start paying their first. They'll pay 95%, you pay 5%. The problem is that $250 million isn't defined in PREA to say whether it's a specific company that has to pay $250 or if the whole industry has to pay the $250. Either way, think about this. 5% of what amounts to trillions of dollars. You're talking literally billions on top of billions of dollars and hundreds of billions. One estimate that we received was minimum of $500 billion that the government is asking the insurance companies to pay out. And mind you, people, this is a federal regulation that has been submitted to the House of Representatives.
Nick, with your phone calls, with the people from around the country, do you get any sense in the likelihood that this would actually pass in some form?
That's what I was about to say. I can tell you from experience that the Republicans have said flat out, I will never vote for this. There is almost zero chance it passes as constituted. And the reason is twofold. One, the Republicans have asked, and I spoke to a specific representative who said, and this is a quote, how many Republicans have signed on for this? I'm not going to be the first one. And also said there is no way I can vote for this or I'm getting kicked out of office. The biggest problem, number two, the reason it won't pass is there were no, well, third problem, there's three reasons. Second reason is there were no premiums collected for this. So you are looking at constitutional issues out the wazoo if they pass this. There is no way you can go back and say, I know you have a contract and contract law that said, we will compensate you for X amount of coverage. You know what? It doesn't matter. We didn't give you anything for that coverage. You're getting it for free now. Number three, the insurance industry will go bankrupt in a heartbeat. There are certain carriers, I don't want to say Liberty or CNA or certain other carriers, Liberty is definitely in the forefront of this, who have said, go ahead and pass it and I'll be bankrupt tomorrow. And you will get nothing. And there will be no big insurance companies to write these type of policies, because if you're being told you can't cover a risk that you agreed to, and we as a government are now imposing this on you with the theory that you will be able to issue additional premiums in the future to cover this. Do you know how much would have to be added on to the premiums to cover this?
So Nick, with that logjam on the federal level, from the state level, obviously the states don't have the financial wherewithal to give the backing like the federal government does. But are there any states in this area that have also considered or have passed some type of legislation addressing the same issue?
Yes. And the bigger issue for the states is this. The states don't care if the insurance companies don't have the money. State legislatures are more specific. They are focused on their voting polls. And as far as they're concerned, they want their area and their local and state people to be taken care of by the big insurance companies. So they are trying to pass these. I can tell you right now, let's focus on some local states here, Pennsylvania, New Jersey, New York. There are legislative submissions that have been made. Not one of them has gotten out of its initial stage. Not one of them has been put to subcommittee vote. Not one of them has been put to vote. The odds on them passing are slim to none. Back for the same reason. And remember, you also have the insurance industry has some pretty powerful lobbyists. The insurance industry is lobbying behind the scenes to address this. That's issue number one. Number two, there are other issues that the legislations have, both at a state and federal level, have placed on a higher pedestal for now. Specifically, the biggest issue is the racial tension that is existing now in the United States. Their concerns, that has taken a forefront focus for now for both the state and federal legislatures. So for that reason, not alone, but for that reason, a lot of this has taken a backseat. But let me ask, does anyone else know of any state legislative action that's been taken on a local, state, or federal level?
Like Maryland.
Yeah, how about
You
Maryland?
guys are in Maryland.
No?
I have not seen anything.
It wouldn't surprise me, and the reason for that is really simple. I don't think that they are focused on trying to force the insurance industry to change its practice. Because again, you can have whatever arguments you want that this should be covered by insurance, despite the exclusions, despite the lack of coverage for it, despite the lack of a payment for it. But they realize without the insurance industry being willing to cover these losses, what happens to any company that's being run by your restaurant? What happens to your life insurance? Think about this. If the insurance industries go out of business, you have the Rock, you have Allstate, you have your State Farms, you have your larger companies that do not only write business interruption and general liability. You have many other lines of coverage. I mean, you have your life insurance, you have your disability insurance. If an insurance company goes out of business, what happens to that? What happens to someone who's injured for comp? And the comp carrier says, you know what? Yeah, I did write that, but I got forced to use my money to pay for business interruption. So life insurance, GL, now we're done.
And Nick, what happens there when the the insurance companies go under? Every state has their own insolvency plan that ultimately the states end up paying for a lot of that anyway.
Yeah, and the problem with that is the states, you're talking about the, for example, the liability and property and casualty or property and liability insurance guarantee associations.
Right.
The problems with funding the I call them the LIGAs. You got NJ PLIGA, property and liability. You've got PIGA, PIGA, Pennsylvania Insurance Guarantee Association. The property with the LIGAs is, or LIGAs, I guess, I don't know how you pronounce it, but the PLIGAs we call it, is they are funded 100% through collections of a surcharge on insurance companies. If there are no insurance companies around, who is going to fund PLIGA?
Yeah, if you look at every declaration page, the bottom, there will be a surcharge.
Yes.
That's where it goes.
So
Nick,
can you?
I don't mean to interrupt you, but we have about 10 minutes left, and I have about 30 minutes of prepared remarks, and therefore, my homework was for 30 minutes, 25, 30 minutes, and I don't want to overrun 2 o'clock. So could you close and just let me contribute?
Absolutely. So in closing, my question should be very simple. Are there any questions that anyone on this roundtable has concerning the issues of coverage, language, government action, notice of claims, cancellation, restaurants? Any questions that you have?
I have a quick one. I'm just curious. I know that there are those companies, or I've heard that there are those companies that have a virus exclusion on the property side of things. And then I know that there are some companies that are maybe operating on old forms or unique forms where there is no virus exclusion. And I was just curious if anybody on the call here is aware that, I know there will be one-offs, but in general, is the industry's response still pretty much that, taking a no-pay position? Or are there some carriers that may have policies with no virus exclusion, an alternative? I'm just curious.
Tony and I discussed that, Carmel Tarak and I discussed that, because we are very familiar with one carrier who is actually one of my clients who does not have that virus exclusion. Tony, do you want to address this?
Well, not so much. I mean, right now, they haven't been hit with any claims yet, but they are anticipating and circling the wagons, both from trying to still write business in the future, but they're also starting to calculate the type of claims they can come in. But there is a carrier that does not mention virus in their policy, in their standard form. I think it might be an older form. And they're looking at having some serious issues going into the future. There should be a lot of litigation coming out of it, and Nick's got a lot of the defenses we've already talked about, but lacking that exclusion, they understand that they are a large target as of yet. Nick, I don't believe they've actually gotten a single suit yet. I believe they've received a number of notices, but we are aware that there's some brewing, right?
Yes, and Brian's also been involved in this as well, because it's a mutual client of our department. We are talking right now, they are at the highest level of the carrier is addressing this issue because they are scared.
Yeah.
They know they made a mistake with their policies. And after SARS, everyone started to include this language, but they did not. So industry-wide, there are not as many claims as you think. It is just certain carriers that don't have it. But as a whole, the ones that do not have this exclusion are gathering around, and they are trying to figure out what the reason is. And their main defense is no property damage.
Okay, may I jump in?
Absolutely, Lou.
All right, thank you. I'm looking at an ISO form, which is CP 01400706. I found this in a Hartford Mutual policy. It's entitled Exclusion of Loss Due to Virus or Bacteria. And it says, we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical illness, distress, illness, or disease. And it says the terms of this exclusion do not serve to create coverage for any loss that would otherwise be excluded under this coverage part of the policy. That exclusion is as close as I can get to a defense in the current ISO forms. So I suggest that, at least in terms of Hartford Mutual, you look for this in your policies, whether it be in your big OP or your CGL. Let's talk about litigation. Currently, there is no COVID litigation in the state of Delaware. There is one lawsuit that's been started in Pennsylvania, and there are 3 in New Jersey, 2 of which are being handled by the same plaintiff's firm, both in the U.S. District Court in New Jersey. They are both purportedly class action lawsuits for 2 restaurants, one in Summit, New Jersey, and one in Union, New Jersey. They are the putative plaintiffs. The lawsuits sound in declaratory judgment actions against, the first action is against Chubb for basic coverage and extra business interruption and extra expense and breach of contract, and to break the civil authority exclusion. And the second lawsuit, which is also a class action lawsuit in New Jersey for the second restaurant, mirrors the same causes of action. Okay, having said that, we are realistically stuck with the history that we have in our policies. But based upon my conversation and my conference call with the infectious disease doctor last week, he and I have prepared a prototype of an exclusion which we feel, that I feel legally and he feels medically, if it were incorporated into any policies going forward, would be a bulletproof exclusion for viruses such as COVID-19. And I'd like to take the liberty of reading this to you It's still a work in progress, so please understand that. So let me begin. This is a predominant omnibus insurance policy exclusion that supersedes all insurance coverage provided under this insurance policy, and it changes the policy. Please read it carefully. If you have any questions or concerns, please contact your insurance agent or broker or your attorney for clarification or explanation. The insurance coverage provided in this insurance policy specifically excludes all damages or losses sustained by you resulting from, and here's the list that becomes critical to surviving this type of virus. Any virus, I'm going to repeat that. Excludes all damages or losses sustained by you resulting from any virus, bacterium, parasite, pathogen, microorganism, or infection capable of inducing physical or emotional distress, illness, or disease, even if such is known or unknown at the inception date of the insurance policy, including COVID-19. 2, resulting whether or not it's characterized as an epidemic or a pandemic, still excluded. Whether or not transmitted by or through air, water, human, animal, or any other living or deceased species, excluded. Whether or not any of your damages or losses are caused by or contributed by bioterrorism, excluded. Whether or not your damages or losses are directly or indirectly caused by or contributed by such disease from any source. Whether or not your damages or losses arise from any civil authority or governmental orders. And whether or not any of your damages or losses are caused or contributed by acts or decisions, including the failure to act or decide of any person, group, organization, or governmental body. And now I'm going to define damages and losses that we have, my doctor and I decided would be the best definition. Damages and losses include, but are not limited to, any temporary or permanent physical, emotional, or mental ailment or condition to the person. Any temporary or permanent business or personal revenue or profit losses. Any temporary or permanent physical damage sustained to your personal or real property, interior or exterior, including contamination. Any restoration, rebuilding, replacement, removal, or remediation expenses. Any temporary or permanent computer or electronic data damages or losses. Any temporary or permanent equipment breakdown damages or losses, or any temporary or permanent spoilage of product. Lastly, under no circumstances is such a virus, bacterium, parasite, microorganism, or infection to be considered a, quote, covered cause of loss, period, end of quote. So having said all that, I think we as defense attorneys and the insurance industry who are participating with us on this Zoom conference can understand how much is missing in our current policies that would serve as a total defense to COVID-19 and other bacteria and viral claims. Thank you.
Lou, thank you for that. It reminds me of the environmental coverage litigation in the 1990s, where landfill there was what was known as the pollution exclusion, which was pretty clear, but the courts messed around with that. Then they came up with what's known as the absolute pollution exclusion. So I would call Lou's exclusion I really mean it, no virus exclusion.
Yeah, right.
We're up against the time. I want to thank everybody for their participation. If you have any questions, you have our contact information. If you want to get Lou's work in progress for his specific endorsement, it's going to have LN 2020 on the bottom left of the page. Or if you want to get in contact with Nick for the most recent legislative, federal, state updates, please feel free to contact us. And thank you, gentlemen, for your time.
Thank you,
Brian,
Al.
before we close out, I know that we had this recorded. Do you know if this is going to be available on our website if in case anybody wants to go back or show it to their to their coworkers who missed it? Donna may be able to help us with that.
I'm
Yeah,
sure
we-
it can be.
Yeah, we can make it available.
Great.
I'll double check with everybody, make sure you're happy with it before we put it on the website, but we can definitely share it individually with anybody who wants a copy.
Great.
Well, thank you, everyone. Thank you for joining us. And
And
thank
have
you.
a happy 4th, everybody.
Hey, you too. Thank you.
Thanks for hosting.
Thanks, folks.
Thank you.
Thank you.